So what I'd like to start out, first of all, I wanted to give everybody the materials. A lot of the stuff I'll be talking about is in there, so that you can at least have it to take home and refresh your memory. It's also a very good sleep aid for those with insomnia. But I want to kind of start off by kind of giving you general information about wills, trusts, all the different things that we will eventually then get to the point of being able to talk more specifically about how these things really do affect the lives of persons with disabilities. So we'll talk about things to give general information such as a will. What is a will and what does it cover? What does it do? So when we're doing wills, we always want to remember that my will, for example, will only control certain things. It'll only control the assets or property that I have titled in my name alone at the time that I pass on. So there's things that go outside of a will. Primarily those things are things that I might have titled as joint tenants with someone. Maybe a joint bank account, maybe a home that's titled in joint tenancy. That's going to go directly to that surviving joint tenant. Doesn't matter what I put in the will. And anything that has a beneficiary designation, again, it goes to the beneficiary and doesn't matter what I put in the will. So when we think about doing planning about how we want to have everything go after we're gone, we really need to know how everything is titled and what beneficiary designations there are. Because when I do wills for people, I want to make sure that I know exactly how everything's going to go to make sure that it will go the way that they want. Now, there are advantages of doing a will. Even if we say to ourselves we don't have a great deal of property to pass on, well, the other advantages are that you name in your will who's going to be personal representative for your estate. It used to be called executor or executrix for a woman. And that person's obligations and power is to collect your assets, pay whatever debts there are, and then distribute the property according to the will. So you're naming who you want to take care of things. Certainly for a parent with a minor or a disabled child, you also can name in your will who you want to be the guardian for that child. Now, a guardian is the person who makes medical decisions and living arrangement decisions for the child. And we'll talk a good deal about that as we get going here. By the way, if you do have questions, ask them as we go. I don't really want to wait till at the end. It's much better to ask them when you think of them. And again, you can raise your hand or just shout out because it's a big facility. I really can't see you that well. Okay. So that's kind of what a will is. Now, what's a trust? We hear a lot about trust. Well, what is a trust? A trust is a document, and it's a series of instructions as to how you want the property or assets that you put into that trust managed and then distributed. So there's a lot of different kinds of trust for different purposes. It all really depends upon the language that you put in the document. Okay? Now, the person who actually creates the document, signs the document, that's called the grantor or settlor of a trust. A trust is set up for a beneficiary. The beneficiary is the one who's supposed to receive the benefits from that trust. And it is the trustee that is named who's going to be the person who will manage that trust and the money and make the decisions about distributing the money for the benefit of the beneficiary. In general, you can divide trust into two kinds. One is a revocable trust, and the other is irrevocable. And they're just what they say in the term. A revocable trust means I can change it, amend it, cancel it anytime that I want to. Now, there might be certain restrictions in the document that might limit me from doing it. For example, if there's a joint revocable trust by husband and wife, it may be that the document says that both of them have to agree if you're going to amend or change the trust. But a revocable document in general is one that can be changed as long as you have the mental ability to change it. So if I do a revocable trust, but down the road for some reason, maybe I have an accident or whatever it might be, if I lose my mental capacity to understand legal documents, I don't have the ability to change it anymore, and then it becomes irrevocable. Now, an irrevocable trust is just that. You can't change it. Once you do the document, it's irrevocable, and nothing can be done to change it. You can't change the beneficiary, can't change the terms of the trust. A trust that's created in a will, called a testamentary trust, that becomes effective, the will becomes effective when the person passes on. So that kind of a trust is irrevocable because it doesn't become effective until the testator, the person who created the will, has already passed on. Now, the other thing about looking at trusts, and these will be important as we get along later on in talking about what kind of trust we may want to, establish for a disabled child or adult. There's a difference between what's called a first-party trust and a third-party trust. So here's kind of what that means. First party means me, okay? So for a first-party trust, I'm the one who creates the document. I'm the grantor. I'm the one who, it's my assets that go into that trust. And usually I'm the primary beneficiary of that trust. And usually I'll be the trustee. But a first-party trust, the key is it's my assets that go into that trust. A third-party trust is a trust that's created by somebody else. And it's their assets that go into that trust. An example is a grandparent. The grandparent creates a trust. They're the ones that are the grantors. They create the document. They put their assets into the trust. They're not really the beneficiary. They may be creating that trust for the benefit of their grandchild. So the grandchild's the beneficiary. And maybe the grandparent is the trustee. Maybe they'll name a next trustee after they're gone. But it's a third party who creates it, and it's a third party's assets who are in that are in that trust. Special needs trust, okay? Special needs trust is kind of a broad category of a trust that has language that talks about special needs, okay? The idea behind a special needs trust is that it is intended to provide not the normal requirements for basic living expenses such as food, clothing, and shelter. It's designed to provide for other things, special needs, things that will make the life of the beneficiary better. Okay? And we'll talk about that further down the road here. The other thing, next thing that's in kind of my handout about trusts is what's called sometimes a discretionary trust. So a discretionary trust means that the language says that the distributions are in the discretion of the trustee. Trustee makes the decision about what to distribute and when to distribute any assets or income or benefits from the trust. And again, just like all trust, it all depends upon the language that you put in the document. So that's kind of like the general information about trusts. Any questions about any of that so far? Okay. Next thing we talk about is powers of attorney. Okay. So when I'm talking to clients about doing their estate planning, they're going to be doing maybe a will, maybe a trust. They're trying to then do planning to say how things are going to go with their resources after they've passed on. Powers of attorney are during our lifetime. So the example that I give about why powers of attorney are so important kind of goes like this. If I ever got into an accident and I lost my mental ability to be able to make my own financial and medical decisions, I've thought in advance, and I've done powers of attorney so that my family can take care of those things for me. Now, if I didn't do that, They might have to go to the court to be appointed as my guardian for medical decisions. They would certainly have to go to the court for appointment of a conservator to take care of my finances. So for example, if I own a car or a home or a bank account and it's in my name and I can't take care of that anymore, someone has to have the legal authority to be able to go and access those assets. Well, if I didn't do a financial power of attorney, nobody has the power to do that. And that's where a conservator in the court has to be set up. Well, that's a court proceeding. It takes time, it takes money, and the judge makes the decisions about everything. So I don't want that to happen. So I always recommend that people ought to consider doing powers of attorney to take care of those decisions and take care of those things. Yes, ma'am?
If everything is done jointly, then that's probably not an issue. Is that correct?
That's not correct, I'm afraid, but it's a very good question. Okay, so say you have a joint bank account, okay? If you have a joint bank account, either one of the joint owners can write checks on the account, okay? It may become a little more difficult if you have a joint savings or a money market account, something like that, or if you have a joint investment account. Very often then it's going to be requiring both signatures. If you have a car that's titled jointly, both people have to sign the title if you're going to sell the car. If you have a home, both people have to sign. When we own property as joint tenants, that only really means that after one joint tenant dies, the other joint tenant is going to own the property. And a joint checking account is really the only example of where, gee, if one can take care of everything and you don't have to have both signatures. But in most other things, you do have to have both signatures. So, and when I mentioned about how if I didn't do a financial power of attorney and I lost my mental ability to do things, my family couldn't sell my car, even because they didn't have the power of attorney to do it. So that is a very good question because it's a very common misunderstanding that, gee, everything's joint, everything's fine. Well, it's not. Now, when we do a power of attorney, one of the things we always have to remember whenever we're talking about any of these legal matters is a question of a person's mental capacity. So in the law in Colorado, a person's mental capacity to do things varies depending upon what you're asking them to do, okay? So for example, to do a medical power of attorney, the person has to have the ability to understand what that power of attorney means and what it does. And what that is that power of attorney for medical matters is you're giving the authority for the person that you're naming, called the agent, the power to make medical decisions for you if you could not make those decisions yourself. So as long as we're able to make our own medical decisions, we make them. So a medical power of attorney really becomes effective if we can't make those medical decisions ourselves. Now, if I have a person who needs to do a power of attorney to transfer title to a car, it's a very limited circumstance and a very limited thing that they have to understand. They just need to understand that you're going to give this person the ability to transfer or sell that car. On the other hand, when we usually will do powers of attorney in planning, we're doing what's called a general power of attorney. And what that means is I'm giving the power for my agent that I name to take care of all of my financial matters, no matter what it might be. Well, that means I need to know what my financial matters are, because I need to know then what power am I giving to this person that I'm naming as the agent. So that's a much higher standard. We need to know what our assets are and what power we're giving for that kind of a power of attorney. Now, okay. One of the things I put in there and an added little handout at the end is my handout regarding advanced medical directives in Colorado. And so I'm going to briefly describe what those are. There's basically three kinds of advanced medical directives that we can do. Now again, this is a person if I have the ability to understand and do documents and do medical directives, I'm making these directives now in advance of, in the event that I ever became incapacitated and couldn't make those decisions myself. So the first one is the medical power of attorney, which is the one that I think is the most important of them, because it does name who you want to make those medical decisions if you can't. And my recommendation always is that you pick the person that you believe best knows what your wishes would be and will be able to follow them. So for example, and I've got clients a number of times that will say, I want to make my daughter to be able to make my medical decisions if I can't, because I think she really knows what I would want best. And then they go talk to the daughter, and the daughter says, you know, I couldn't do it. I couldn't make any kind of final medical decisions if that became necessary. So you name not only the person that you think knows what your wishes are, but would be able to follow them. The second kind of advanced medical directive is what we sometimes call a living will. And it's basically a statement saying we don't want life-sustaining treatment. There's no form now in Colorado, but the language that's usually used and is directed somewhat in the Colorado statutes kind of goes like this. It says, if I'm not able to make my own medical decisions, and my primary doctor and one other doctor certify in writing they think my condition's irreversible and terminal, then I don't want to have any life-sustaining procedures like being on a respirator. It goes on to say that if that ever happened and they took off all other life-sustaining treatment, we can choose whether we want to keep artificial nutrition or tube feeding after that. So it's a very, very limited circumstance. You know, 2 doctors got to certify being in terminal condition, that kind of thing. When I do these documents, usually my recommendation and usually what clients will prefer is that we combine those two, or we put them together, the medical power of attorney and the living will. And when we do that, we want to put in the medical power of attorney, which is going to be controlling. And usually clients will say that I would rather have my agent that I've chosen to be my medical power of attorney, that person make final decisions and not the doctors under the living will. But we want to say which one of them is going to make those decisions. The third kind of advanced medical directive is what's called a no CPR directive. And that's all it covers. It means if my heart stops, I don't want to have cardiopulmonary resuscitation if that happens. The only effective way to get that document done is through your doctor, not your lawyer, because the doctor needs to sign off on it. Doctors have the forms for that. And the reason is that they want to make sure that the doctor has explained CPR and the consequences of doing it or not doing it. It has become the tradition that if a person does that and they're at home, they will take that no CPR directive and they'll put it on the refrigerator door. That's the first place that paramedics will look when they come into a house and they know that the person's heart stopped. And they will recognize it if they see the form that's signed not only by the individual but by the doctor. So that's why you really need to get that form from your doctor. All right, any questions about any of that stuff so far? Yes, sir.
Is that date sensitive then? Should it be reinforced like annually?
The question is whether or not the no CPR directive is date sensitive, and no, none of these documents are really date sensitive. Unless you put in the document itself that it's going to expire on a certain period of time, they continue, okay? Now in the handout at the end of my materials here, you'll also see that I've got information about what's called the MOST form, the medical orders for scope of treatment. And what that is it's a form that on kind of hard paper, 2-sided, and it is meant to be a summary or a compilation of what your advanced medical directives are. So it's not really its own individual medical directive, but it's supposed to be a summary. The idea behind it when it was first set up was for persons who are either in a long-term care facility or who have chronic health problems. And the idea was that If you're in a facility, for example, that should be the first thing that's on the top of your chart. So if that individual then, for example, has to go to a hospital, that goes with them. So that there's very clear statement as to do they want CPR or not, do they have a medical power of attorney, who is the agent, those kind of things. And again, that's signed by the doctor, and it can be updated, and if it is, the doctor needs to sign on the update. So that's all in that little handout that will help you go to sleep. The next thing in the materials is about guardianship. So let me just ask a little bit, are there persons here who currently have experience with the guardianship system? There's a couple, okay. So a guardianship is established through the court for a person who is incapacitated, meaning that they are not able to make their own medical or living arrangement decisions. Now, there can be a guardianship for a minor. Usually we don't need a guardianship for a minor. Usually it is the parent who's going to be able to make those decisions for the minor. And the minor in this case, a guardianship ends at age 18. If we have then a situation where we then need to have a guardianship for an adult, then the process basically goes like this. We will usually get a letter from the physician stating what the abilities and disabilities are for the person. We attach that to a petition to have a guardian appointed. We file that with the court, giving notice to all interested persons, which is basically the family. And then the court sets it for a hearing, usually 30 to 45 days down the road. The court appoints a visitor who is a volunteer who for a small fee will go out and basically try to be the eyes and ears of the court. They will go out and they will try to talk to it's called a respondent. That's the person you're seeking to get the appointment for. If a guardianship is established, they're called the ward. So they will try to first speak with the ward. They will advise the ward of their rights, their right to have an attorney, their right to present evidence at the hearing, the right to object to having a guardianship, all of those kind of things. They will talk to the petitioner, and they'll talk to any other persons who may be able to give them information. They may then go and review the medical records for the person, and they'll do a report to the court before it comes up for hearing. Their report is basically focused on the two things that the court's going to have to decide. Is a guardian necessary, and who is the appropriate guardian? Now, Colorado law says that the court is really supposed to look toward a limited guardianship if possible, meaning that even though it may be necessary for the court to appoint a guardian, the court really hopes to be able to provide the ward with as much ability as possible to make as many of the decisions as they can, okay? And so even though they may not be able to make their own medical decisions because they're not really having the ability to understand the requirements of giving informed consent to medical treatment, they might be able to decide, for example, what they want to look for in terms of a placement, where they want to be in terms of a placement, if they have to be in a placement outside of the home, those kind of things. Now, when you apply for a guardianship, the petitioner has to submit along with their petition what's called an acceptance of office, and with that, basically it's a questionnaire saying, have you ever been convicted of a felony? Do you have any outstanding judgments against you, etc. They have to submit a criminal records check from the Colorado Bureau of Investigation and a credit report. Those things are really, to be honest, primarily focused on persons who are seeking a conservatorship as well. A guardianship is for medical and living arrangements. Conservatorship is to take care of finances. Okay? You can do them all at the same time, same procedure, but that's what the difference is. One other thing then that I want to explain in terms of this general information about the overall picture about things before we get into special issues relating to disabled persons is there is also a law in Colorado called the Proxy Decision Maker Law. And what that is this. If a person has never done a medical power of attorney, naming who they want to make medical decisions if they can't, and then they're incapacitated, well, do we always have to go to the court to be appointed, have a guardian appointed? And the answer is no, because we have this medical proxy decision maker law. And what it basically says is this. It says that if a physician believes that their patient cannot make their medical decisions, they don't have the ability to understand and give informed consent to treatment, then the physician has to look to somebody else to make that decision for them. So the physician would first look to see if that person has done a medical power of attorney or not. If they haven't, then the physician is supposed to determine who would be the appropriate person to make those medical decisions. They're supposed to inquire about family. There's no specific hierarchy as to who should be appointed as a proxy decision maker. So if, for example, it doesn't go spouse first, parent second, adult child third, those kind of things. No, it just lists possible interested persons, which are the family, and even what's called a close friend. Okay, so these are all interested persons that the physician, or usually is going to be the physician's assistant, is going to try to locate to determine who is the appropriate person to make medical decisions. The appropriate person really ought to be whoever is best situated to know the most and the best information about what that person's wishes would be. The physician then signs a form saying that they want to designate the particular person to be the proxy decision maker. The physician is supposed to talk with the patient to make sure that they understand that the physician has decided that he or she doesn't think that the patient can make decisions, and that he's designated this person to be the proxy decision maker. Now, if any interested person, family, objects to either who is appointed to be the proxy decision maker or objects to any of the decisions of the proxy decision maker, they can go to the court to be appointed as a guardian or seek the appointment of a guardian. I always tell clients sometimes that this works in really the simple situations. The example being, dad has a stroke, can't make medical decisions, and everybody in the family agrees mom is really the one that should make those decisions for him. So in simple situations where there is really a broad agreement by everybody as to who should be the decision maker, it works. And then you don't have to go to the court really to have a guardian appointed. Okay. Any questions so far? All right. So then let's kind of, having that general background information, let's talk a little bit about special issues or things that might apply. Okay? When we talked about first-party trust, third-party trust, if you remember, first-party trust are assets that, if it's my trust, they're my assets. Now, a common circumstance that this happens is where we have a disabled person and they receive an inheritance. Well, that creates issues for them, okay? And when parents come in to do their wills or to make their planning for their children, this also plays a part in their decisions. It is a common thing when people aren't really looking toward good advice, I think. They will look and think, well, I don't really want to, I've got 3 kids, for example, and one of them is disabled. So I'm not going to leave anything to that disabled child. I'm going to leave everything to the other 2 kids. And the other 2 kids will take care of my disabled child. Well, there are risks. So say we give just the assets to those 2 children. They're in those kids' names. What happens if one of the kids gets divorced? Well, those assets that I really hoped would be used somewhat for my disabled child, they may be lost in that divorce. What happens if that child, the healthy child, dies? That child's will is going to say where their assets, where mom and dad's assets went. And they may go to the spouse or someone else that is not going to provide for their disabled child. That child that they gave the money to may go bankrupt or may use all of the money. So when I see situations like that where people have done that kind of what I kind of call informal planning, it's not really well thought out about all the risks that you take when you do that. Now you compare that to, okay, I've got 3 kids, one of them's disabled. I'm going to make my estate, it's going to be equal among the 3. You 2 guys get your money, but the money for the disabled child we put into a trust. Now the advantage to the trust is, it is money that's only supposed to be used for the benefit of that disabled child. It's not the money of the other 2 kids anymore. We name who we want to be the trustee to make the decisions about the use of that money. Since it's in a trust, that trustee is under the legal obligation to use that money only for the benefit of that disabled child. So there are protections, and we'll talk a little bit more about how we best create that trust or what kind of a trust to do. But that to me is a much better way of looking at it than simply saying, well, we'll give the money to the other kids and they'll be able to take care of their sibling. Yes, ma'am.
How does that impact Social Security? If
Okay.
you put money into a trust for your disabled child and they're on Social Security, how does that impact that?
Okay. All right. Let's talk about that now. Okay. So it depends upon to some extent, it depends upon what Social Security benefits they are receiving. Okay. So let me explain a little bit about that for a disabled person, there are 2 different kinds of Social Security benefits. One is Social Security Disability Income, SSDI. Okay. The other is Supplemental Security Income, which is SSI. And there's a huge difference. So think of it first, not in the sense of a minor child, but think of it just for a person, for an adult. If the person who can no longer work or is not able to work, and they have enough of a work history, or if they have a deceased parent who has enough of a work history, they may receive SSDI, Social Security Disability Income. And their ability to receive that is based solely upon their ability to work or not. Okay? It doesn't matter what assets they have. They can be a millionaire. I can get, not me, I'm not, but a millionaire could get SSDI simply because they're not able to do what Social Security calls any gainful employment. And their any gainful employment this year is about $1,100. So a person who gets SSDI can get their benefit, they can still go out and work, but they're just not able to really earn more than that $1,100. So they can get both their SSDI and the $1,100 and up to $1,100 approximately in income. But it doesn't matter what their assets are. Okay? Now, SSI, Supplemental Security Income, is a needs-based program. So it does matter what their assets are. So the requirements really in general for SSI, yes, they're not able to work because they're not able to earn a living and do gainful employment. And they have a low enough, or they don't have a work history at all, they may get SSI. The maximum this year for SSI is $733 a month. Now, for that SSI recipient, they can keep certain things. They can keep a home. They don't count a home. They don't count a car. But in general, most other assets are all what they call countable resources, like a bank account. So their countable resources have to be below $2,000 in order for them to stay on SSI. So in answer to your question then, how does doing a trust affect a person's ability to continue to draw their Social Security benefit? So let's say I have a parent and they're going to want to do a trust. Maybe they put it in their will. We want to have a trust for a disabled child. Well, if that child's going to be receiving Social Security disability income, it doesn't necessarily matter about the trust. The trust assets of that parent, that's a third-party trust, remember. Okay, it's not the assets of the child, it's the assets of the parent. And we'll talk a little bit that more when we get a little bit further into this, because that's a real important difference. But the idea behind doing the trust in general, in answer to your question right at the beginning here, is if you do the trust right, it's not going to affect their Social Security benefit. Okay? They're still going to be able to receive, whether they receive SSDI or SSI, they're still going to be able to receive those benefits if the parent does the trust right. Okay? The next thing I had in my handout about this question is, okay, what will the disabled child need in the future? That's the most important question that has to be answered as we're doing planning and as we're trying to then create a trust. Because we want to know what do we have to put in that trust document that really is going to provide for that disabled child and make their life better. Okay? Now, let me kind of give you a couple of different examples, and that might help to explain the other parts that we're going to be talking about here in terms of the trust. So let's say I have parents come in and they want to do a will and they want to do trust for their disabled child. And again, those are the questions that I'm going to be asking. I'm going to be asking, what kind of public benefits are they on? Are they on SSI? Are they on Medicaid? Okay, Medicaid comes with SSI, right? And what do they really need? So let me give you two different scenarios and you'll see the difference. In the first scenario, the parents may tell me that their child really does, and this would be a child who's a minor or a child who's an adult, okay? That the child needs help with all activities of daily living, dressing, bathing, transferring. They're not able to ambulate, okay? So it is known that this person really is going to be needing a great deal of assistance throughout their life, and that really the cost of that is really going to end up having to be paid for by Medicaid, because that's what's going to pay for those benefits. Okay, and we know that maybe from the information that the parents give me that the child really might be able to benefit from certain things. They might be able to benefit from companionship, going on trips with a companion, assistive technology. So there may be certain things that we want to make sure that we put in that trust document that we're directing the trustee to look to be able to make that child's life better. But we're going to probably be relying upon public benefits to pay for the basic living expenses such as food, clothing, and shelter, mainly food and shelter. So the child may be in a host home. The child may be still living at home but receiving services in the home. Okay? So we're looking at wanting to make sure we don't disqualify that child for those public benefits that they're entitled to, because that's what's really going to give them the basic living expenses. other end of the example here is parents come in and they'll say that they have an adult child, but the child is able to do a good deal of things. The child is able to pretty much live on their own independently. They may need some assistance in terms of getting to work, transportation. They do get to work. They don't have enough ability to make a full living. They're receiving maybe SSDI, so they're getting some benefit. They may be working in a supported environment that is helping to be able to then help them work and earn income, but they're able to do so. Well, in that circumstance, we're going to do a different thing with the trust, okay? And here's where we talk about the difference between special needs trust and discretionary trust. A special needs trust will usually have the language that is very directed toward making sure that the public benefits will pay for food and shelter, and that the special needs language will say that the trustee is to use the trust money for other things other than the basic living expenses. Well, that would be very applicable to that first circumstance where we know that the child is going to need those public benefits for their lifetime, and it will be those public benefits that will provide for their basic living expenses and needs. A discretionary trust goes like this. It just says, what we call a purely discretionary trust says the trustee can distribute income or principal or both for the benefit of the beneficiary in the sole and absolute discretion of the trustee. Okay? Now what that means is, in the law, basically, that because those decisions are completely in the discretion of the trustee, the beneficiary could not force distributions. Beneficiary couldn't go to a court, for example, and say, gee, you know, the trustee needs to distribute money for me. Court would say, well, no, it's all in the discretion of the trustee. The advantages to that kind of a trust for our discussion here is not only could the beneficiary not force distributions, the beneficiary's creditors couldn't force distributions. Public benefits programs cannot force distributions. So remember, this is a third-party trust. It's not the beneficiary's money, it's the parent's money. Okay? And the parents set it up and say, we just want this to be in the discretion of the trustee. Now, what does that do for that second scenario where we have the child who is able to work, but really is going to probably need some help? They may need some help to help pay for rent or utilities or food or the other basic expenses of living. They may get SSDI, but they may only get $800 or $1,000. They may be able to work, but they only may be able to earn $500. They may need some of that trust money then to help them pay their expenses. So by putting that language being at a discretionary trust, the trustee has the ability to help them with those things. It's not just limited to the special needs trust language that restricts really what the trustee has the ability to distribute it for. And the trustee will then have to be able to look to, okay, what are the benefits that the child is receiving, and how do we then plan around those and distribute what we need to be able to help that beneficiary with not only special needs, but with other money that they may need for their lifetime. So that's the key difference in when we look at these things. That's why I said that the most important question at the very beginning with the family is, what do you anticipate really will be the needs for this child as they go through life? Because that will guide the language that we put in the trust. It will guide what our planning is going to be for the distributions from that trust for the child. Okay? Questions? No. All right. Now, another question that's often raised in this context is, what about the home? What do we do with the home? Okay. Now we're talking about a home that the parents are living in. Okay. It may be the home, the only home that the minor child or the adult child has ever lived in. Okay. How do we then plan after the parents are gone with what to do with the home? Do we put the home in the child's name? Do we put it in the sibling's name? Well, if you put it in the sibling's name, you got that same kind of problem we talked about before, which is you're relying on the siblings to take care of the disabled child, and you're relying on the siblings to not get into debt or to not get divorced or not to die, right? Or do we put the home into a trust? The preferred thing for me always is to tell the clients, you put the home in a trust. Okay? By doing that, that can have several advantages. The first advantage is, again, it's a third-party trust. So the assets in that trust aren't really the assets of the child. And so they're really not going to be counted against the child's eligibility for public benefits. If I have a home that, maybe I have a situation where the adult disabled child may well need to have services coming into the home, or maybe that the adult disabled child may really need to live in a host home. Well, there's always a possibility that the home could be considered or used as a host home. The advantage to that is that when we have host home situations and you have maybe 2 or 3 adult disabled persons living in the home, sometimes conflicts arise. Well, if the home is actually in the trust that's for the benefit of my disabled child, and that my disabled child does not get along with the other persons in the home, they're going to leave. My child's not going to leave. Right? That may or may not work because it depends upon what programs that are available. Very often host home situations now really want to be situations where the persons who are the caregivers are actually there, it's their home, as opposed to having to bring in 24-hour caregivers. But it can work at times. You know, sometimes parents will think, well, I'm going to put the home just in the name of that disabled child because they can keep that home because it's their home and therefore it's exempt and they don't count it for SSI or Medicaid. Okay. You got to be able, however, to plan and make sure there's enough money to take care of the home, keep it up, and again, it depends upon what the income's going to be for that disabled child. But what happens when you can't keep it up? What happens when the home needs to be sold? Well, if you put the home in the child's name and then it has to be sold, now it's cash. And that's cash of that disabled child. So then if that child has to set up a trust, and we'll talk about that in a minute, that's a first party trust because it's the disabled child's money. Okay, just like if they received an inheritance, it's their money. And that's what would have to be then a first party trust. Okay? So, what do we do when the disabled adult child has money or gets an inheritance and receives money? Well, we don't want them to not be knocked off public benefits, especially if they need them for a living. So we can establish a first party trust. There's 2 different ways of doing it. One is what's called a disability trust, and the other is what's called a pooled trust. So again, remembering these are first party trusts. It's the child's money that's going to go into this trust. Now, federal law in 1993 established the ability to do these two things, these two trusts. And basically the general picture is that the money that's in that trust, even though it was the disabled person's money, if you put it into these trusts, we're not going to count it for Medicaid purposes. This doesn't work for like Section 8, okay, but it does work for Medicaid and SSI. And the reason it works that way is because those trusts have what the disability trust has to have what's called a payback provision, meaning that if there's money in that trust when the disabled person passes away, that money first goes to pay back Medicaid, whatever's left. Okay? Now, the disability trust has its requirements. It can only be established, remember it's a trust document, and so the grantor, the person who can establish it, has to be either a parent, a grandparent, a guardian, or the court. Those are the only ones who can create the trust. As we have older persons who need to do these trusts, parents are gone, grandparents are gone. We either have to then have a guardian in place or we have to go to the court to get it established. Okay? The trust itself has to be approved in advance by the state Medicaid department. The trust will be required to provide an annual accounting to Medicaid to show what money was used and it was not given away to somebody else other than the benefit of the beneficiary, the child. But it is a way of preserving that money. I mean, if the person got an inheritance and you didn't do this, they're going to be knocked off SSI, they're knocked off Medicaid, and the money will just be used until it's gone, and then they can get back on. But if you put it in the disability trust, then that money could be used to make their life better. Okay? The other way then to do that is what's called the pooled trust. Pooled trust is, the trustee is a nonprofit organization. The primary one in Colorado is called the Colorado Fund for People with Disabilities. So there are a number of different, there's a pooled trust arrangement. All of the money is pooled together, but each trust has their separate account. Colorado Fund for People with Disabilities, there's the trustee. They go out, they try to determine exactly what would be the things that would make this person's life better. They make the decisions about distribution. The difference then is at the end of the trust, if the child passes away, instead of the money first going to pay back Medicaid, that money would stay in the pooled trust, thereby allowing the money to maybe be used for other disabled persons who have pooled trusts. For a small amount of money that's inherited, sometimes this is a very good thing. You don't have to worry about who's going to be the trustee, and if that child's money in their trust runs out, they may still be able to get benefits from the pooled trust money that's sitting in that pooled trust from other disabled persons who have passed on before them. Okay? For a disability trust, you have to be under age 65. And for a pooled trust, there's currently litigation that's been going on for a while as to whether or not all of the money that you put into a pooled trust, if you're over 65, is going to still be able to benefit the individual. But that's just still to be decided. So any questions about a disability or pooled trust? Remember, again, those are first-party trusts. That's the money of the disabled person. Okay. Boy, you guys are really getting it, or I'm not doing a good job, one or the other. Can you guys still hear me back there? Okay, good.
I have a question.
Yes, sir.
Back to the selling of the house and having more than one child and one disabled. Is there any possible way of doing a trust that would funnel that disabled child's portion into the discretionary trust and enhancing that with the funds from the house?
Well, what you would do is actually when you create the trust, whether it's in your will or however you create the trust, if the discretionary trust is the appropriate way for it to go, you'll put that in the document in the first place.
Okay, so you just incorporate it at the beginning.
That's right. And then it will actually be that trust that will own the home. So the home will be titled in the name of the trust. You know, you may put other money into the trust as well so that there's money to pay for ongoing expenses and for things that maybe will make the child's life better in addition to the home. Certainly that's the ideal circumstances if we have money that we can add to that trust so that there's not just the home in the trust, but the trust itself will be created in such a way to make sure it's going to provide whatever that disabled child needs, the best way. Okay. One of the things that we're hearing about now are what's known as ABLE accounts. Has anyone heard of an ABLE account?
What was it, ABLE?
ABLE? It's a federal law. It's called Achieving a Better Life Experience. They're calling it the ABLE accounts. Well, I'm surprised you haven't heard of it if you're in this community. But then the other reason you probably haven't heard about it is it's not available in Colorado yet. Hopefully it will be next year by the time that they can get regulations done to enable people to open them up. It's a little bit different, but it's similar to a disability trust. Again, this is money of the disabled child. And the idea behind it is that, first of all, the requirement is that the disabled child has to have been diagnosed with the disability prior to age 26. So that's the very first requirement. So they either have to be receiving SSI or SSDI based upon a disability that happened before age 26. Or that if they aren't on SSI and SSDI, again, their diagnosis has to have been prior to age 26 that would have qualified them for Social Security. The advantage somewhat is that the disabled person can actually be the person who opens up the account. They can only have one account, but they can actually be the person who opens it. They can be the person who can manage the money, make the decisions, and spend the money out of that account. It is limited to donations that might be going into that account of $14,000 per year. That's the tax rule. But so parents could put money, or grandparents, or whoever could put money into this ABLE account for them. And then the disabled person could use that money. And the money then basically is, again, not going to be counted against their eligibility for SSI or Medicaid. The distributions, once they use the money, it could cause issues for their SSI and Medicaid if they use it for food and shelter. Food and shelter. So there are some limitations on its usefulness. There's a whole page or so in here about that, the ABLE account. Since we don't really have any immediate interest, or we don't even have the ability to do it yet until hopefully next year, you can read through that and see. Now, one point I'd like to make about it, though, is if the money that's coming that's going to go into that ABLE account is really coming from a parent or a grandparent, personally, I think it's better to simply do a third-party trust. You don't have, and the reasons are, there's several reasons. One is a disability trust. You know, these first-party trusts, whether it be the disability trust or whether this is not really a trust, the ABLE account, but it's similar. The first-party money, that's the money of the disabled person, that's going to be looked at every year very carefully by SSI and Medicaid. They're going to look and see what your expenses were. Did you do it right? Okay. They give people a hard time, for example, if some of the money is used for the disabled child to go on a trip. Well, they don't mind the paying for the disabled child, but how about the companion? Oh, no, you can't do that. That's really benefiting the companion. It's not benefiting the child. Well, I disagree, and you'd have to battle that with them. But think about those kinds of situations where first-party trusts are going to have a great deal of scrutiny. So if you're a parent or you're a grandparent, You don't want to have that happen. You want to set it up in a third-party trust when it's very clear that none of those assets are the assets of the disabled child. And when you put in there how you want your distributions to be made, you make those decisions, and it doesn't matter what SSI or Medicaid says. So if you put in your third-party trust, you put in your trust and say, well, it's going to be used for special needs, but one of those special needs is to pay for a companion so my disabled child can go on a trip or go on outings. Well, there's nothing Medicaid or SSI can do about it. It's not the child's money, it's your money. It's a third-party trust. So instead of putting money maybe into an ABLE account, you put it into a trust that you create and make it how you want it and how it's going to benefit your child the best. And what kind of expenses and things would make that child's life better. Okay? All right. Yes, sir.
So as far as guardianship, I'm gonna go back to that.
Sure.
So if your disabled adult child has Medicaid, but then they lose Medicaid, is the guardian then responsible for any medical bills that are accrued after that, or how does that work?
Okay, we're kind of forgetting about why you lost Medicaid. Right?
Just if it happens,
So the focus on the question is just what is the responsibility of a guardian?
yeah,
Okay. So now a guardian is responsible to make living arrangements and medical decisions. If there's no conservator appointed, I mean, if there is a conservator appointed, the conservator is supposed to take care of the money, right? So if there is no conservator and there's maybe a small bank account, or then maybe the guardian's the one that's going to be in control of that money. And so let's say that, as in your question, the adult disabled child's on Medicaid, maybe they have medical bills, they go off Medicaid, and now they got medical bills, and they're coming after money. Well, the guardian, or conservator, if the conservator is in there, their responsibility is to use the money of that disabled child, not their own money. Now, if they misuse it, yeah, they're going to be responsible for it. But if they don't misuse it, and if the child just runs out of money, then the guardian or the conservator, if they've acted properly, they're not responsible out of their own money to pay for the expenses of the ward. Does that answer what your question is?
Yep.
Okay. All right. Now, one of the other most important things that everybody needs to consider as you're thinking about these things is the people that you name. Whether it's a guardian that you name to be nominated to be a guardian in your will, or a trustee for the trust for the disabled child. Who are you going to name? If this may well be a very long-term job. You want to probably name at least one alternate. If this person passes, who's going to be the next person to be the guardian? Or maybe even another person after that. Or who's going to be the trustee? Yes, Larry?
Chuck, can you have co-guardians?
Yes, you can. And again, though for a guardianship, that's through the court. And so you can petition to have co-guardians. Sometimes that is indeed what people will do. And sometimes the idea behind it is, gee, if one of the co-guardians does pass or becomes incapable themselves, there's already a guardian in place. So not only is the guardianship proceeding in place, but the guardian's there, so that then that guardian can either act as a sole guardian, or if that guardian wanted to say, gee, I'd like to add someone else and have the court appoint another co-guardian, so there's someone here to act as a guardian for the ward, then yes, you can do that. Similarly, for a trust that you're creating, when you create the document, you can name co-trustees, okay? For a similar purpose, or maybe you want to name co-trustees because maybe one really is going to take care of the financial matters most of the time, but the other one is going to be available to help. But again, you want to think about these as long-term jobs, and how long is it going to last, and who do we need to name as trustee? You certainly, of course, need to name someone you trust. So even though we put assets into a trust, even though that person has, as the trustee, has the legal obligations to use that money only as it's supposed to be used, well, what happens if they misuse the money? What happens if they take it or lose it? Yes, you would have a legal claim against them, but if they've already spent the money and they don't have any money that you can get, then you're in trouble. So again, you name persons or persons that you trust. So the last kind of few things on the last page here are things that I suggest people do and things I suggest they not do. And this is true in all planning, no matter whether we're talking about disabled children or adults or just simply doing our own planning. Do proper legal planning. Don't do things informally. Now that might sound self-serving. It might sound, gee, he really wants to have you go to lawyers to do these things. However, the reality is that you really do need to do things right. The example that I give when I do programs for people for doing estate planning for general purposes is, so many times I've had people put a child's name on a bank account. And they do that for a couple reasons. They say, well, if I get sick or if I'm in the hospital, my daughter can go ahead and write checks and take care of my bills. Or if I pass on, well, she can write the check for the funeral home. So I really want to, I put my daughter's name on the account. Well, one thing I tell them is that when you do that, after you pass away, that money is going to go to your daughter. She's under no legal obligation to share it with her siblings. But the other real problem is, I tell everybody a true story. This happened to me where I had a client call me up and said, I put my son's name on my bank account, and he wrote himself a check for $100,000. How do I get it back? And the answer is you can't. Just like you could clear out the account, he can clear out the account because you put him on as a joint owner. So you don't do things informally. Get good legal advice before you really do things. Next thing you don't do is you don't listen to your neighbor, okay? Because you don't know what the neighbor really did. You don't know what their circumstances were. You don't know if what they did was really going to work for you or your family. And you don't know if they got good legal advice before they did it either. Don't procrastinate. We always do, okay? But don't put things off. I mean, if you don't have the ability mentally anymore to do powers of attorney or do a will or set up a trust for your disabled child, you can't do it anymore. So you don't want to just put it off or think, well, I'll do it down the road when I need to. The other thing is talk with your family about these things. You want to make sure that whatever you do, it's going to work. The example I gave about how you do a medical power of attorney, you go talk to your child, and the child says, no, I couldn't do it. I couldn't make those decisions. Well, you want to find out how things really would work. If you're gone, who's going to be the trustee? How will this really work? Who's going to be the guardian? Who will really take care of your disabled child? You want to talk with your family. It's not easy stuff to talk about, but you really want to know that what you're doing will in fact work. And the last thing I just put down is be careful about legal forms. I mean, you see all the forms on the internet and other places, and again, this might sound self-serving, but it's really not. I mean, too often what happens is that if you don't do the form right, or if you don't pick the right form, you've just created a huge problem. When we're doing these kinds of things, when we're creating a trust or doing a will, we're trying to make things as easy as we can for our family. But if you don't do it right, you've really created a problem for them. So do things well, do it right. That's all I've got.